good. Well, good afternoon. I'm David Ammons, Chair of the Washington Public Disclosure Commission, and I will be the presiding officer for today's hearing. The time is 3:18 p.m. The hearing is being conducted under the authority of RCW 3405, the Administrative Procedure Act, WAC 390-28, and RCW 2217A. The hearing is being held at the PDC office in Olympia and is being audio recorded. Today I will be hearing two cases, and they will be handled by two different staff members who have sent out information ahead of time. I have reviewed the record for each case, and each respondent has been given an opportunity to appear in person or by phone or waiving the right to appear, and it is my understanding that neither of the respondents in these cases chose to appear in person or by phone. Correct?
That is correct.
I will ask the staff to present. Why don't we handle these one at a time since they're somewhat different. Tabitha Townsend, would you introduce yourself for the record? And I'd like to, well, you're already sworn in from earlier in the day.
Mm-hmm. I'm Tabitha Townsend, Compliance Coordinator.
Very good. And would you tell me about case 59761, Tony Overmeyer?
Yes. Tony Overmeyer was a 2019 candidate for Des Moines Park and Recreation Commissioner. It was alleged there was a violation of RCW 4217A, 205, 210, and 215 for failure to timely file campaign registration report with the PDC within 2 weeks of becoming a candidate or no later than June 3rd, 2019. Did you want the breakdown of the details?
No, I don't think that is necessary. Would you tell me the staff recommendation?
Yes. The staff recommends that the Commission find Tony Overmeyer violated RCW 4217A, 205, 210, and 215 for failure to file a candidate registration report within 2 weeks of becoming a candidate, and assess a $500 penalty in accordance with WAC 390-37-143. The brief adjudicative proceeding penalty schedule adopted by the Commission for a second time violation where the candidate did not file the C1 report before the date of the hearing and did not enter into a statement of understanding.
Could you summarize efforts to reach Ms. Overmeyer?
Yes. The Communication and Outreach Department sends out several reminders prior to their deadlines. And after the complaint came in, November 4th, I sent 4 separate emails and called 3 different times, as well as sent an initial hearing notice, and mailed the hearing notice for today, as well as emailed.
And you got no responses to any of those efforts?
No responses.
Okay. Well, having heard the staff recommendation and the presentation of the case, I would find that Tony Overmeyer in case 59761 did violate RCW 4217A 205 for failure to file a candidate registration C1 report within 2 weeks of candidate, or no later than June 3rd of 2019. I will further, having found that there was that violation, I will concur in the staff recommendation for penalty, which will be $500 in accordance with the penalty schedule adopted by the Commission for a second-time violation, and I further order that it be paid within 30 days, and that there be, if she does stand for election or otherwise need to file paperwork with the BDC, that she be in compliance for the next 5 years. Is there anything else to close this one?
No, sir.
Very good. The time is 3:24, and the hearing on this particular case will be concluded. And Jennifer Hansen will be sworn in, and then present Martin Morgan, PDC case 58694. So, Jennifer, would you raise your right hand? Do you swear or affirm that the testimony and background that you give will be the truth, nothing but the truth, so help you God?
I do.
Would you present the case?
Yes. This particular case involves Martin Morgan, who is a 2019 candidate for Kirkland City Council. Mr. Morgan was declared candidacy in May of 2019 and was also required to file a C1 and F1 as a candidate within 2 weeks of his candidacy declaration, or by no later than June 3rd. Mr. Morgan was the subject of a complaint that was filed on October 10th by David Asher. That complaint alleged various things, including a failure to file the C1 timely. At the time that the complaint was filed on October 10th, Mr. Morgan had already filed the F1 that was required to be filed. In addition, Mr. Morgan has a previous violation that was entered according to order in August of 2015. The presiding officer at that particular brief adjudicative proceeding found him in violation of not filing the C1 timely, RCW 4217-205, and assessed us $100 civil penalty in accordance with what was originally WAC 390.37.165 and is now codified as 390.37.143, or the brief enforcement penalty schedule. And the presiding officer suspended the entire amount on the condition that Mr. Morgan commit no further violations. So staff is in the process of investigating the complaint that was filed by Mr. Asher in October of 2019. Staff found that Mr. Morgan had not filed the C1 timely. And in addition, during their investigation, we found that Mr. Morgan had also not filed the F1 timely. That was not alleged in the complaint, but staff added it to the investigation and added it to the allegations. Mr. Morgan was also given an opportunity to file timely through the reminder process that Ms. Townsend indicated in her case. Mr. Morgan received at least 2 reminders from customer service and filer assistant staff. He also had an initial hearing, so he received an initial hearing notice and the results of those notices. Mr. Morgan has had communication with staff about filing the C1, which was missing at the time that the complaint was filed, but has had no further communication with staff since then, regardless of the the additional information that was both emailed to him and mailed through the U.S. mail. The most recent being the brief enforcement notice, which was sent to him through email and through the regular mail. Mr. Morgan has, at this point, filed both the C1 and the F1, although they were both late.
So, in being compliant after being notified of the hearing, what is your recommended penalty?
So Mr. Morgan had filed both the C1 and the F1 prior to the hearing notice, so he is currently in compliance as far as the outstanding reports that were due. And he did choose mini reporting on the registration that he filed the C1, so he doesn't owe any additional reports regarding his campaign. But given the previous violation and the conditions that were part of the previous order that was entered in August 21st of 2015, staff is recommending two things. First of all, that the presiding officer finds Martin Morgan in violation of RCW 4217-205 for failing to timely file the C1 within 2 weeks of becoming a candidate for 2019, and for in violation of 4217A-700 for failure to timely file the F1 within 2 weeks of becoming a candidate. Of course, both of those were due by no later than June 3rd, and they were filed late. And that the presiding officer assess a $300 penalty, $150 per each late report, in accordance with the penalty schedule, which can be found in WAC 390-37-143. For a second violation where the missing reports have been filed by the date of the hearing. In addition, staff is recommending that the presiding officer find that Martin Morgan violated the conditions of the order entered in August 2015 in PDC case number 16-210 by failing to timely file the C1 and F1 reports by June 3rd, 2019, and to reinstate the $100 penalty. So it would be a $400 penalty total, $300 for the current violations for the 2019 late filings of the C1 and F1, and then to reinstate the $100 penalty that was suspended. The time period for that condition, just for the record, expired in August of 2019. However, staff is asking the presiding officer to consider that the violation actually occurred the day that the reports were late, which would have been June 4th, 2019. And that at that point, Mr. Morgan had not filed the C1 and F1 required to be filed as a candidate for 2019. And at that point, he had violated the conditions of the previous order. And so that it is appropriate for the condition for the suspended portion to be reinstated.
So did you say it was a 1 day late in paying the penalties, the previous?
So the previous order indicated that if Mr. Morgan had had a violation of the conditions of that order within 4 years of the date of the time that the order was entered, that the $100 penalty would come due. So he had the entire portion, the entire penalty amount suspended based on no future violations for 4 years.
Yeah.
Normally, staff would look at the time that condition expired, which would have been August 21st of 2019. But in this case, staff is asking you to consider the fact that Mr. Morgan was actually in violation of these conditions the day that the reports for 2019 were due, which was in June rather than in August. So even though you had not yet found a violation, the presiding officer had not found a violation, and the commission had not found a violation, staff is recommending that you consider that the violation actually occurred the date that the reports were past due, and that every day from the point that they were past due until the date Mr. Morgan filed the C1 and F1, he was in violation of 4217, A205, and 700. I have the details as well about how many days late the F1 and C1 were, if that is of interest to you, Chair Ammons.
And you had limited contact from him to try to cure it earlier?
We did, yes. And he was given actually 2 opportunities to complete a statement of understanding, acknowledging a violation for each report, for the late C1 report and for the F1 report, and to also acknowledge a violation of that previous condition. And he did not respond to either one of those. And he did not respond at all to the initial hearing that we had in order to convert this particular investigation to a formal investigation so it could be heard today, and he did not respond to the hearing notice either.
And we got no bounce backs from
Correct.
email or surface mail?
We're using the same email that he did respond to before, so.
Okay. Well, thank you, Jennifer. I do believe that the record before us does show a violation of RCW 4217A 405 for failure to file a candidate registration report in timely fashion, and RCW 17A 700 for failure to file a personal financial affairs statement, F1 report, both due within 2 weeks of becoming a candidate and not later than June the 3rd of 2019. Having found these violations, I am assessing a $300 penalty for the failing to timely file a C1 report within 2 weeks of becoming a candidate, and for, for 12 calendar months prior to becoming a candidate due within 2 weeks of becoming a candidate. And there were 2 reports, the C1 and the F1, and so it would be $150 for each late report in accordance with the penalty schedule adopted by the Commission for a second violation where the missing reports have been filed by the date of the hearing. I further concur with staff recommendation to find that Martin Morgan violated the conditions of the order entered into on August 21st, 2015 in case 16-210 by failing to timely file C1 and F1 reports by June 3rd, 2019, and would reinstate the suspended $100 penalty. So the total penalty then for these violations will be $400. An order will be issued within 10 days, and with the requirement to be paid within 30 days, and for no further violations should he seek office. Is it 5 years or 4 years?
Typically, you've done 4 years, but for Tabitha's, you did 5 years.
Okay.
I think you could do either one.
Okay. Well, let's say 4 years. And so that'll be the order of the presiding officer. Thank you. And that will conclude our hearing. It is 3:37. Sorry I'm a little rummy. It's been a long day.